Lawyers are famous for speaking legalese, a legal language that seems foreign to those outside the industry. Maybe your own estate plan contains legal terminology that seems archaic and confusing at first glance. But once we translate these phrases to layman's terms, your estate plan will become much easier to understand. Hi, I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. In this video, I'm going to explain 5 confusing terms that may be in your estate plan. Number 1, issue. Many clients read through their estate plan and walk away scratching their heads over the term issue. When your trust discusses your issue, it is referencing your lawful blood descendants in the first, second, or any other degree. The term child or children is similar but less broad. It refers to lawful blood descendants to the first degree. Do adopted children count as issue or children? Yes. When your trust uses the words children, this usually includes legally adopted children and their lawful issue, meaning offspring born to married parents. Number 2, per Stirpes. The term per Stirpes is a Latin phrase found in many estate plans. Latin was once the universal language spoken by the educated class, including attorneys, which is why many Latin terms continue to be used in legal documents today. The literal meaning of per Stirpes is per branch. Per Stirpes is a method for distributing property according to a family tree, where descendants take their share of deceased ancestors would have taken if their ancestor were living. So if your son died and left behind 3 daughters and your trust is distributed per Stirpes, then the daughters would inherit their father's portion of your estate. Number 3, power of appointment. You might notice that your trust grants a power of appointment to an individual, usually a beneficiary. If a person is granted power of appointment by your trust, that individual can appoint property to others, either upon the termination of their interest in the trust or other specified circumstances. The individual given the power is usually referred to as a holder of the power. The power of appointment may be general, allowing the property to be appointed to anyone, including the holder. Alternatively, the power may be limited, allowing the property to be distributed to a specified group or to anyone other than the holder. By giving a beneficiary a power of appointment, you are giving them a power they wouldn't otherwise have, such as allowing the beneficiary to add further beneficiaries to the trust. Number 4, Settlor, Grantor, Testator, Testatrix. All of these terms serve to name a person creating a legal document. The term used will vary depending on what legal document they're creating. A settlor or a grantor is a person who creates and contributes property to a trust. A testator or testatrix are Latin terms for a person who creates a last will and testament. Number 5, executor, executrix, personal representative. All these terms have a similar meaning and refer to a person named in a will and appointed by the court to carry out the terms of the will and to administer the decedent's estate. These terms are only applied to estate plans administered in the California Probate Court. If you've created a revocable living trust to avoid probate, your estate plan will instead be administered privately by your chosen successor trustee. So that's it. 5 estate planning terms explained. To access a free downloadable estate planning glossary, visit our firm's client resources page, where we'll link in the description box. If you have any questions about any of the terms used in your estate plan, feel free to contact our office. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.